231,653, compared to 196,081 cases reported in the previous year of 2021. The report further highlights that a total of 1,091 cases of theft of motor vehicles were reported to the police in 2022, while a total of 5,675 cases of theft of motorcycles were reported to the police in the same period under review. So when we're talking about vehicles, of course, motor vehicles in this sense, it's not just cars, but boda-bodas, as we understand them, motorcycles, tuk-tuks, all those that use a motor to run, and as long as they have a number plate. So a further interesting highlight from the report is that out of 24,111 vehicles involved in crashes or accidents, 139 of these were unregistered. This would ideally mean that it makes it harder to resolve such accidents involving unregistered vehicles. The report does not offer any highlights on unresolved crimes or ongoing investigations or prosecution of crimes involving the use of vehicles. Of particular interest are quite a variety of crimes involving the use of vehicles as a means of getting away. For instance, what comes to mind are the old tragic instances such as the roadside murders of John Kagezi, Muhammad Chirumira, Andrew Felix Kawesi, Major Chigundu, and the General Katumba Wamala shootings, to mention but a few. Looking at the broader statistics, the Ministry of Works and Transport, which depends on records from Uganda Revenue Authority Registration and Licensing Department, states that as of 31st May 2023, there were 1,820,474 vehicles in the country. From the perspective of the Uganda Police Force and the Directorate of Prosecution, it would be helpful to monitor and address crime leading up to its prosecution basing on vehicle ownership. This is buttressed by one of the strategies for enhancing investigations, as mentioned in the annual police report of 2022. And this strategy is to the effect that the investigating personnel intend to apply more science in investigations, which involves the use of CCTV cameras, application of forensic science, telephone tracking equipment, and so on. The strategy does not directly mention the use of digital trackers on vehicle number plates, though it can be argued that this is where they would fall. So what are the concerns under data control? It begs the question as to where the digital number plates project falls. It is known to be part of the country's Intelligent Transport Monitoring System, ITMS, to increase efficiency in sectors of transport and security. The ITMS is said to be jointly implemented by the Ministry of Works and the Ministry of Security. In April 2023, the Ministry of Works and Transport issued a statement to the effect that it was taking over the registration of motor vehicles from the Uganda Revenue Authority. And this was to be aligned with government's implementation of the ITMS to be provided by a company known as Joint Stock Company Global Security, which is a Russian company. This company is to provide a centralized vehicle register where sensors are to be inbuilt into the registration plates. Under this project, every motor vehicle driver in the country will receive a new license plate incorporating technology that enables law enforcement agencies to identify both the vehicle and its owner precisely and quickly. The new registration plates are projected to cost 714,000 shillings, up from the current cost of 150,000 shillings. According to the Ministry of Security, the high cost of the digital plates is justified because the Russian company running the project is investing all its money into the project and intends to recoup from its investments. The ITMS is projected to ensure that the data is accessible right away in case of an emergency, a car theft, or an accident, which leads to quicker resolution of the incident through the identification of criminals or traffic violators. This will thus simplify the process of issuing traffic fines and also deter poor road behaviors and detection of crime suspects. However, the ITMS project has apparently left out the Ministry of Internal Affairs, under which the Uganda Police falls. So where are the projected strategies highlighted in the Uganda Police Force annual report to be impacted? According to media reports, the Ministry of Internal Affairs is of the view that the government contract with the Russian joint stock company, Global Security, is likely to conflict with an earlier contract signed with the Chinese company Huawei, which provides CCTV security cameras to the government. Besides the issue over a likely contractual breach, the ownership and use of personal data is also of concern. Data safety is about how agencies collect and share data. The use of the ITMS will be about monitoring and access to individuals' movements based on the data provided with regards to registration numbers for motor vehicles. In another sense, their ownership and constant location at all times. Privacy of data, therefore, comes to mind. Article 27 of the 1995 Constitution of Uganda provides for the right to privacy. However, this is not a non-derogable right. The government can exercise its prerogative to deprive any individual of his or her right to privacy, especially where matters of national security are involved. Objective 3, Roman numeral 1, of the National Objectives and Directive Principles of State Policy found in the Constitution provides for national unity and stability. It is to the effect that all organs of state and people of Uganda shall work towards the promotion of national security, peace, and stability. The emphasis here is on peace and stability. The government therefore gives priority to peace and stability, which are pillars of national security, when the right of privacy comes into play. Needless to state, however, the utilization of personal data in fronting national security, such as is being proposed through the ITMS, marginalizes a number of principles related to private data. With respect to the principles of data protection, the Data Protection and Privacy Act of 2019 provides under Section 3 to the effect that a data collector, data processor, or data controller, or any such person shall observe security safeguards in respect of the data. This means that such data is not to be misused or allowed to fall in the wrong hands. Bearing in mind that the data collector, processor, or controller, in the case of ITMS, involves a private party, which is the Russian firm, it is of concern as to how such data will be protected and utilized. It is therefore important to ensure that the global security company works closely with government agencies in the use of personal data drawn from the digital plates. Then there's, of course, the issue of consent in the collection of personal data. Section 7 of the Data Protection and Privacy Act is to the effect that personal data cannot be collected without consent of the data subject. However, under Section 7, subsection 2b, it may be necessary to collect or process such data for national security. Therefore, on matters of national security, we look at Section 18 of the Anti-Terrorism Act of 2002, which is to the effect that the minister in charge of internal affairs may designate a security officer as an authorized officer, and then with Section 19 of the same act, it empowers such an authorized officer to conduct surveillance of a person under the act. Ideally, the Minister of Internal Affairs would therefore be the one to authorize an officer to undertake surveillance under the ITMS. However, it appears that ITMS is under the Ministry of Security, and the mandate of Internal Affairs has been sidelined, as mentioned earlier. The government should have clear channels of operation and owes a duty to its citizenry to point out how the ITMS will be operationalized and under whose docket it will fall. This is premised from Section 3 of the Data Protection and Privacy Act, which provides for accountability and transparency in data collection and utilization. In the absence of respect for the principles of data protection as stipulated under Section 3 of the Data Protection and Privacy Act, such surveillance and monitoring of personal data can be deemed unlawful and therefore a violation of not only Article 27 of the 1995 Constitution, but also Article 12 of the Universal Declaration of Human Rights and Article 17 of the International Covenant on Civil and Political Rights. Both international instruments of which Uganda is a signatory provide to the effect that no one shall be subjected to arbitrary or unlawful interference with their privacy. According to the UN Human Rights Committee General Comment number 16 on the right to respect of privacy, family, home, and correspondences, and protection of honor and reputation, under Article 17 of the Universal Declaration of Human Rights, it states that even interference provided for by law should be in accordance with the provisions, aims, and objectives of the covenant, and should be in any event reasonable in the particular circumstances. So mark the word that it should be reasonable in the particular circumstances. Under the same General Comment number 16, paragraph 10 states that the gathering and holding of personal information on computers, data banks, and other devices, whether by public authorities or private individuals or bodies, must be regulated by law. Effective measures have to be taken by states to ensure that information concerning a person's private life does not reach the hands of persons who are not authorized by law to receive, process, and use it, and is never used for purposes incompatible with the covenant. The government of Uganda is therefore obligated by law to guarantee the integrity and confidentiality of data collected through ITMS. Such data falling in the wrong hands or being utilized for purposes outside of what it is meant for, which is curbing security in the country, would be a breach of this obligation and a breach of the international principles of the on the right of privacy. Section 21 of the Data Protection and Privacy Act provides for security measures relating to data processed by a data processor. It is envisaged that the Ministry of Works is the controller of data in this sense, since it is in charge of collecting and controlling information relating to vehicle registration. It is also envisaged that the Russian firm is to be the data processor under ITMS. It should be ensured that the contract entered into between the government of Uganda and the Russian firm abides by the provisions of Section 21 of the Data Protection and Privacy Act. Subsection 2 of this section is to the effect that such contract relating to the processing of personal data requires that the data processor establishes and maintains confidentiality and security measures which are necessary to protect the integrity of personal data. It is therefore not simply a matter of legislating over surveillance through the Data Protection and Privacy Act, so as for the government to show that it is fulfilling its obligations in respect to the right of privacy. In the famous US Supreme Court case of United States versus Jones, the key questions for court's determination were: 1, whether the warrantless use of a tracking device on the petitioner's vehicle to monitor its movements on public interest violated the Fourth Amendment, and 2, whether the government violated the respondent's Fourth Amendment rights by installing a GPS tracking device on his vehicle without a valid warrant and without his consent. This is a case where a gentleman called Enrico Jones, who was a suspected gang member and was into distributing drugs, cocaine and things of that nature, had a device placed on his car when he had parked somewhere, and the FBI used that tracking device to monitor his movements and then used that evidence against him in a later charge. So the court concluded that Jones had a reasonable expectation of privacy in his movements, and that the GPS tracking constituted as such under the Fourth Amendment. And the Fourth Amendment in the US Constitution protects people from unreasonable searches and seizures by the government. So by way of conclusion, we are all wary of the increase in insecurity in the country and the need for more effective means of curbing the crime rate. As such, government efforts should balance out various interests and be seen to be respectful of the individual's right of privacy, and the use of the ITMS should be approached cautiously, bearing in mind that a disregard to the principles of data privacy may do more harm than good. Thank you very much.
Stephen Napo is a global information security expert. A statement he made some time back makes more sense today more than anything, because the conversation is about data protection and privacy. And he said that digital freedom stops where that of the users begin. And he continued on to say that nowadays, digital evolution should never or must no longer be placed to a customer in a trade-off between privacy and security. Why? Because privacy is a valuable asset that should be protected. So we should say a big thank you to the unwanted witness upon holding, of course, a data protection and privacy dialogue, because this is evidence enough that on the scale of their priorities, it is actually at the top. And also a reminder that many social and government activities across our different countries usually collect big data for one reason or another, because they have to upgrade their online systems. But in doing so, there are a couple of questions that usually arise. Can we confidently trust our governments that this big data that they usually collect in upgrading their online information, even if it is to inform public health, can we trust that they store it and actually keep it safe, following the legal or even actually the regulatory frameworks that are all in our countries?
Privacy is purely a moral obligation, and protecting human dignity and other values such as freedom of association, freedom of expression, and at times even freedom to health. The rapid advancement in technology and innovation today can threaten the privacy of individuals. Think about it. Every time you use a service, purchase a product online, visit a building, visit a health center, enroll for a school, or enter in a contractual agreement, you have to hand over some of your personal data. This collection and processing of personal data has greatly reduced the amount of control over personal information and opened up the possibility of a range of negative consequences as a result of unregulated collection and processing of personal data.
The distinguished justices in absentia, the National Data Protection Authority Director, the Deputy Vice Chancellor, who is also our host, representatives from PILAC and the Makerere School of Law, the Motas, students, and distinguished guests. You're most welcome to be part of this day as history is being made.
Themselves. And the point I'm trying to make is why
can be held accountable for issues.
Sure that a non-disclosure agreement is signed. Now
the theme for the privacy moot competition today, which is balancing privacy rights and national security, navigating the impact of surveillance laws on individual freedoms, is thought-provoking and critical for the proper implementation of the Data Protection and Privacy Act of 2019.
The respondents relied on the 2010 decision of Uzun versus the Republic of Germany.
It was the position of the law, it was lawful that we did so, and it could be justifiable in a democratic society.
the GPS trackers in that much vehicles, rationally speaking, I withdraw that word.
My question is, are all the 1.5 million vehicles belonging to people suspected of terrorism?
When the government is interfering into privacy, it must be lawful, it must be pursue a legitimate aim, and it must be necessary.
Unwanted witness is commonly known for the right to privacy and data protection, but we do a whole host of so many things: internet governance, digital inclusion, freedom of expression, but also the mood is just one of those components that we focus on when it comes to the right to privacy.
I want to thank Unwanted Witness for continuing with these privacy moot competitions. They are a good step in the right direction towards building capacity in understanding what privacy is, awareness on matters of privacy, how we can enforce our right to privacy, and also build capacity for the future privacy defenders and practitioners.
Ladies and gentlemen, Code 15 and Code 02, proceed to the finals. Thank you so much.
My lords, we pray that this honorable court grants and declares that the respondent, the acts of the respondent state were not in violation of the right to privacy, and the limitations taken by the respondent state are justified under the principle or the circumstances of national security, prevention of crime, and public safety.
Regulation 12(1) of the data protection and privacy regulation states that where the collection and processing of personal data possesses a high risk to the rights and freedoms of natural persons, the data collector, data processor, and data collector shall, prior to the collection, processing, and carrying out an assessment of the invested collection, shall ensure that they do an assessment.
Chronology is important. The way you present your case. Present it in a way that you're starting from a good introduction, going into the meat of your arguments, and then conclusion is very important. And I'm happy, I like the way it was concluded.
Always identify what the test is. And I think the Deputy Attorney General was trying to do that. But you can be more precise around it.
Citation and use of authorities was fabulous for both teams, and I really want to thank you for that.
I hope that this moot has not only enhanced your knowledge in the area, but that it will trigger debate and information to guide policy makers, especially those from the government of Uganda.
We'll start with the best written submission applicant.
And the winner is Islamic University in Uganda.
Please appreciate them as they come.
Best Oralist Privacy Moot Competition 2023 goes to Martin Kijay.
The first runners-up for the Privacy Moot Court Competition 2023 are Cavendish University.
Already evident. The overall champion for the Privacy Moot
Und ich mit all den Sportlerinnen, mit der dicken, fetten Zugabe
von
Stand up for the champion.
to Nairobi has been a very exciting journey. It began with the launch of the Privacy Symposium Africa in February. We had the first regional engagement of the Southern African countries. Then we had the East African engagement for the East African and Central African countries. This November, we are at Strathmore Business School, and it's the 4th Privacy Symposium.
We are here today for the 4th annual Privacy Symposium Africa, which is an unwanted witness event, and this year is being hosted in Nairobi, Kenya at Strathmore University by SIPIT.
There's the issue of cross-border data flows. How do we then manage, for example, data being shared within EAC, data being shared within ECOWAS for West Africa, data being shared within SADC?
Whatever is happening in this world is data-driven. Look at the companies that use data or are run by data to get an economic advantage. Almost every institution, almost every organization is run by data.
When we have the laws that cater for the specific countries in the East African region, then we can speak with one voice to the East Africa Court of Justice.
So this partnership kind of erases an important safeguard on people's data and just completely tramples on it, which is extremely problematic.
Having unconditional, I suppose, data localization requirements enables and facilitates economic growth, which, in my view, from a human rights perspective, improves the livelihoods. And I think it's an important point just to carry on remembering.
In terms of informed consent, within the privacy policy, what we're looking at is how do they get your consent when you're giving this information? How are you able to opt in and also opt out of this said consent, or is it just standard? Or are you even aware that you're supposed to consent to giving your data?
We thus commit to extend PSA as a platform to different countries in Africa.
I was lucky enough to deliver a masterclass on challenging public-private surveillance partnerships this morning with a wonderful audience and a wonderful group of participants who were extremely able to identify common human rights issues in public-private partnerships.
What I liked most was the expertise of the people who were on the panels. I also liked the keynotes. I think that we need more of this kind of engagements where we can sit and have conversations about our continent and what privacy looks like for us.
I thank the organizers of this fourth Privacy Symposium for the invitation, and I've learned in sharing the knowledge of the digital transformation.
Eye-opening on the challenges that they face when it comes to compliance, and I was also happy that it was an opportunity for us as CPIT to share our experience in helping people know more about the Data Protection Act to our course and the various tools that we have developed.
I would urge various personnel in various capacities from civil society, academia, the government to continue this collaboratory effort to ensure that we have the Africa we want in the data and privacy ecosystem.
in the heart of the Indian Ocean, where azure waters kiss the shores of Port Louis, Mauritius, a beacon of knowledge and enlightenment beckons us. Welcome to the 5th Privacy Symposium Africa, a 3-day odyssey into the realm of privacy, set against the backdrop of this breathtaking island paradise. Gathered here are some of the brightest minds from across the African continent and beyond, united by a common purpose to unravel the complexities of privacy in our age of digital transformation. This symposium is not just a gathering, it is a journey into the heart of privacy, where we seek to harmonize the modern world with the essence of individual protection. At the heart of this year's symposium lies a visionary approach, a compass guiding our discourse, the sectoral lens approach, a beacon that will illuminate the path ahead through the lenses of healthcare, finance, education, information and communication technology. We delve deep into the unique tapestries of challenges and opportunities that each sector presents. Within these hallowed halls, the minds that shape our world will converge. Experts, through leaders and pioneers from every corner of the globe, forging a collective wisdom that will echo far beyond these shores. Together, we will draft a roadmap, a blueprint of a future where privacy is not just a right, but a cornerstone of our digital civilization. As the sun sets over the enchanting horizon of Port Louis, let it symbolize a new dawn. A dawn where privacy is not just an abstract concept, but a living, breathing reality that touches every facet of our lives. Ladies and gentlemen, welcome to the 5th Privacy Symposium Africa. Let our collective voices resonate. Let our ideas flourish, and let our actions redefine the future. Together, we embark on this extraordinary journey, weaving the tapestry of privacy in the age of digital transformation.
The distinguished justices in absentia, the National Data Protection Authority, Director, the Deputy Vice Chancellor, who is also our host, representatives from PILAC and the Makerere School of Law, the Motas, students, and distinguished guests. You're most welcome to be part of this day as history is being made.
Themselves. And the point I'm trying to make is
why can be held accountable for issues.
Sure that a non-disclosure agreement is signed.
The theme for the privacy moot competition today, which is balancing privacy rights and national security, navigating the impact of surveillance laws on individual freedoms, is thought-provoking and critical for the proper implementation of the Data Protection and Privacy Act of 2019.
The respondents relied on the 2010 decision of Uzun versus the Republic of Germany.
Because the position of the law, it was lawful that we did so, and it could be justifiable in a democratic society.
The GPS trackers in that much vehicles, rationally speaking, I withdraw that word.
My question is, are all the 1.5 million vehicles belonging to people suspected of terrorism?
When the government is interfering to privacy, it must be lawful, it must be pursue a legitimate aim, and it must be necessary.
Unwanted witness is commonly known for the right to privacy and data protection, but we do a whole host of so many things. Internet governance, digital inclusion, freedom of expression, but also the mood is just one of those components that we focus on when it comes to the right to privacy.
I want to thank Unwanted Witness for continuing with these privacy moot competitions. They are a good step in the right direction towards building capacity in understanding what privacy is, awareness on matters of privacy, how we can enforce our right to privacy, and also build capacity for the future privacy defenders and practitioners.
Ladies and gentlemen, Code 15 and Code 02, proceed to the finals. Thank you so much.
My lords, we pray that this honorable court grants and declares that the respondent, the acts of the respondent state were not in violation of the right to privacy, and the limitations taken by the respondent state are justified under the principle or the circumstances of national security, prevention of crime, and public safety.
Regulation 12(1) of the data protection and privacy regulation states that where the collection and processing of personal data possesses a high risk to the rights and freedoms of natural persons, the data collector, data processor, and data collector shall, prior to the collection, processing, and carrying out an assessment of this collection, shall ensure that they do an assessment.
Chronology is important, the way you present your case. Present it in a way that you're starting from a good introduction, going into the meat of your arguments, and then conclusion is very important. And I'm happy, I like the way it was concluded.
Always identify what the test is. And I think the Deputy Attorney General was trying to do that. But you can be more precise around it.
Citation and use of authorities was fabulous for both teams, and I really want to thank you for that.
I hope that this moot has not only enhanced your knowledge in the area, but that it will trigger debate and information to guide policy makers, especially those from the government of Uganda.
We'll start with the best written submission applicant.
And the winner is Islamic University in Uganda.
Please appreciate them as they come.
Best Oralist Privacy Moot Competition 2023 goes to Martin Kijay.
The first runners-up for the Privacy Moot Court Competition 2023 are Cavendish University.
Already evident. The overall champion for the Privacy
Und ich mit all den Sportlerinnen, mit der dicken, fetten Zugabe. Stand up for the champion.
In a world where beauty knows no bounds, there exists a haven of serenity, a symphony of nature's wonders, and a tapestry woven with the threads of culture and warmth. Welcome to the Jewel of Destinations, where dreams find their sanctuary. Here, among the laughter and melodies, you will find people whose hearts are as open as the azure skies above. Their smiles are the bridge to the world of stories, a world where every stranger is but a friend yet to be met. Embraced by the arms of progress, this land is a testament of visionary leadership, where innovation harmoniously coexists with tradition. It's a symphony of modernity and heritage, painting a canvas that speaks of a thriving future. Beyond the horizon, where the suns meet the sky, lies a sanctuary for seekers of solace and adventurers alike. The beaches, adorned with the finest grains of gold, whisper tales of forgotten dreams and newfound passions. As the sun dips below the horizon, casting a palette of fairy hues, it reveals a land adorned with the nature's opulence. A sanctuary for explorers, where every step uncovers a treasure trove of wonders, as if the very earth holds secrets in its embrace. This is not merely a destination, but a symphony of experiences, a crescendo of moments that will linger in your heart forever. This is the ultimate holiday, where every heartbeat is a testament to the beauty of life.
This year, the PSA, as it's commonly known, will be in Mauritius. And as you already know, the winners will join these experts in November.
To hear this honorable matter.
Human rights, the Office of the High Commission.
For rolling out the surveillance project.
Can be equal to due diligence.
The overall champion for the private.
Und ich mit all den Sportlerinnen, mit der dicken, fetten Zugabe. Stand up for
Now we are heading to the airport. We are going to pick several guests, symposium guests. We invited several speakers that have started jetting in, so we are receiving the first cohort of speakers that are going to speak at the Privacy Symposium Africa that is going to be held on this Tuesday, 7th to 9th of November. Among those special guests, we have two special individuals, that is Martin Chitio and Ida Gift. These are two students of Islamic University in Uganda who are the overall champion, the overall duo champion that turned out successful at the recently held Unwanted Witness Privacy Moot Court competition.
What's up, Africa? My name is Ida Gift Sambira from IUIU, which is Islamic University in Uganda, Kampala campus, and I was a champion in the Unwanted Privacy Moot competition of 2023, which was held in Uganda. One of our packages was to be in Mauritius to be able to attend what we call the PSA, the Privacy Symposium Africa of 2023. And guess what? I have just landed, I've arrived, I'm excited.
My experience on the flight was really frightening. This was my first time, but it was both full of excitement and also very anxious. She had to hold my hand because I was so scared. But I'm very glad that I'm here in Mauritius, and it is yet the Privacy Symposium Africa 2023. I'm very glad that I'm going to learn very much from very many privacy experts, and I can't wait.